This is Duke University.
Let us come to order. May it please the court. Very good. I'm not going to waste time introducing this panel. It doesn't need any introduction. We will start. We're talking about the Affordable Care Act. We have Neil Siegel on our faculty, Walter Dellinger on our faculty,
yes,
and Steve Sachs on our faculty. All terrific people. Neil, why don't you start?
Good morning. Welcome home. Nobody tell me that this statute is unprecedented. It's also unprecedented that I'm bringing my kids to an event like this. Doesn't make it unconstitutional. Doesn't make it constitutional either. I want to begin with the rationale for certain provisions of the Affordable Care Act, because I think if you understand the rationale for them, it goes a long way towards getting your head around the constitutional questions in the litigation. So there are certain provisions in the statute that guarantee access to health insurance coverage. They prohibit insurance companies from denying people coverage based on pre-existing conditions, from discriminating based on medical history, from canceling insurance, from imposing lifetime limits on benefits. These are technically called guaranteed issue and community rating. I'll just call them guaranteed access for short. Why did Congress impose them? What's the problem that Congress is trying to address? Well, it's 40 million Americans who fall in what's called the non-group market. And as much as they want health insurance coverage, they can't afford it, because in the pre-ACA world, it's too expensive for them. You can imagine the person who loses a job through no fault of her own, becomes very sick or grievously injured, and then that person and her family are in serious danger. Unlike you and me, and unlike everyone else on all sides of the litigation, these individuals, these families don't have access to health insurance coverage, and we know that even people who are wealthy can be financially destroyed by the cost of medical costs. So that's why Congress imposed those provisions. And I should say that they're concededly constitutional. Everyone in the litigation agrees that they're within the scope of Congress's power to regulate commerce among the several states. Congress can regulate insurance companies. It can therefore put terms and conditions on the policies that are sold in interstate commerce. What's controversial in the litigation is the minimum coverage provision, the so-called individual mandate by critics. Why did Congress impose the minimum coverage provision? Well, I can tell you why Congress didn't impose it. No one in Congress or in the White House thought it would be politically popular to require people to buy a certain level of health insurance coverage even if they didn't want it, or else pay a certain amount of money each year. It's about $700 by 2016, or 2.5% of income. That's not the rationale. I think there are two rationales for it. The one has to do with what I just spoke about, the guaranteed access provisions. The second, I think, is separate from that. What happens in a regime of guaranteed access without something like a minimum coverage provision? What do people have a rationally self-interested incentive to do? To wait, right? If you can't be denied coverage once you're sick or injured, well then wait until you're sick or injured to buy it. Why do it while you're healthy? This is a very well-documented problem. It's called adverse selection. It threatens to unravel insurance markets, to cause prices to rise precipitously, thereby undermining Congress's purpose to extend access to coverage to people who presently can't afford it. This would continue to exclude them. So the adverse selection rationale is one rationale for it. Another one is a cost-shifting rationale, that people without insurance in this country still end up consuming medical care to the tune of $50 billion a year, and that's billion with a B. And those costs are shifted to other participants in the health care market, including you and me. What does this have to do with the constitutional questions in the litigation, specifically the minimum coverage provision? Is it within the scope of Congress's enumerated powers? Is it a valid regulation of interstate commerce standing alone? Is it necessary and proper to carrying into execution the concededly constitutional regulations of the insurance companies? Is it a tax as opposed to a penalty, and therefore within the scope of the tax power, even if you don't buy the Commerce Clause and necessary and proper rationales? Well, I'm going to attempt to do something that no law professor has ever done before, and that is comply with the moderator's request to speak for no more than 10 minutes. And so in the 6 minutes that remain, I'm not going to go through all the arguments I've made and all the writing I've been doing on these questions. If you're interested, I'll speak to you for as long as you'll tolerate me. I'm also happy to share my work. I want to abstract from the particular provisions and ask how we ought to think about this from a federalism perspective. Right? What kinds of problems do we think the federal government is best situated to address? What kinds of problems ought to be left to the states? I don't think this is a good idea as a matter of policy or politics or economics. I think it's a great idea as a matter of constitutional law. If we ask ourselves why the Commerce Clause or the Necessary and Proper Clause or the tax power is in the Constitution, it's because of what was going on during the states, during the Revolutionary War, as well as in its aftermath, in the so-called critical period of the 1780s. What we had was a bunch of states acting individually when the nation needed to act collectively. You had collective action problems. You had interstate externalities, ways in which the states were getting in one another's way, taking actions that might have been in their own immediate self-interest, but were contrary to the collective interest of the nation. So, for example, Congress had no power to tax under the Articles of Confederation. It had to ask the states, requisition them for their contributions, and the states said no. Congress had very little money to spend. It's hard to protect a nation during a Revolutionary War or from European powers in its aftermath without much money. Congress didn't have any power to raise and support a military. It, again, had to ask the states for contributions to the armed forces. The states said no. And so, once again, impediments to collective action. Congress had no power to regulate commerce among the several states. You had states acting in the commercial sphere in much the way nation-states act today in the absence of free trade agreements that are respected. These were all collective action problems. If you look at the text of Article 1, Section 8, from the provisions I've mentioned to all the provisions about raising and supporting a military to securing intellectual property rights, bankruptcy protections, immigration law, these are a series of solutions to collective action problems, situations in which the Congress can act more effectively than the states can by acting alone. Indeed, the Constitutional Convention in Philadelphia in 1787 instructed the Midsummer Committee of Detail, which had the job of writing Article 1, Section 8, to lay out specific provisions that would give Congress the power to solve problems when the states themselves were separately incompetent. This idea of separate state incompetence is a term of art. It speaks to this idea that there are certain problems that the federal government can deal with better than the states can deal with by acting on their own. What does this have to do with the minimum coverage provision? I think it has everything to do with it. If you look at it either alone as a matter of the Commerce Clause or as intimately connected to the guaranteed access provisions as necessary and proper to carrying them into execution, I think it explains why the kinds of problems Congress is addressing in the Affordable Care Act, whether you like it or not, whether you think it makes sense or not, these are collective action problems, or at least Congress very reasonably could conclude, which is the traditional standard in federalism cases. Why do I say this? Because we have a country with open interstate borders and mobile participants in the interstate health care and health insurance markets. We know from the experience in the states that when some states guarantee access to health insurance and other states don't, insurers flee. They go to other states in which they can control costs in the traditional way. We know that insurance companies operate in multiple states, and so uncompensated care costs that they have to deal with in one state affects their ability to operate in other states. We know that there's a phenomenon of cross-state hospital use, of individuals on a temporary or permanent basis accessing medical care in other states. One example, the Fergusons are dear friends of mine, and as well as my family. They live in Seattle. Seattle is home to the Harborview Medical Center. It's the only level 1 trauma center in a 4-state region. Uncompensated care costs that start in Seattle don't stay in Seattle. You can tell similar stories about the tri-state area, New York, New Jersey, Connecticut, about DC, Maryland, Virginia, about Mississippi, Arkansas, and Tennessee, right? Various parts of the country in which health care, health insurance operate on a regional basis. There's also a well-documented phenomenon of job lock, of people denying better job opportunities in other states because they can't afford to lose their health insurance. They're guaranteed it in the state in which they're at. They're not guaranteed it in the state to which they have a better job opportunity that they have to turn down. In all these ways, the minimum coverage provision, either alone or in combination with the guaranteed issue provisions, are helping to solve collective action problems among the states. Again, at least Congress could reasonably so conclude. I think this is both a rationale for federal power, and it also helps to identify limits on federal power. This question of limits is key in the litigation. the Supreme Court is not going to uphold an exercise of federal power if it thinks doing so means Congress could regulate in any way that it wants. I think there are 2 limits, or actually 3 limits embedded in what I've just said. And in the 40 seconds, see,
Get the limits out.
35 seconds that remain.
No, I yield my time for you to state the limits.
In the 30 seconds that remain, I'll explain them. First, Congress is dealing with economic problems, not merely social problems outside the realm of markets. And so it respects the limits imposed in previous cases dealing with guns in schools and gender-motivated violence. There's also problems that are interstate in scope. They're among the several states as opposed to internal to a state. I think those are 2 significant limits on federal power. And then the last one I'll just mention is if you think those aren't limits enough, the adverse selection rationale is a very narrow way in which the court could uphold this provision. It's not power to impose any and all purchase mandates or any and all purchase mandates when there are collective action problems, but rather to do so when you need to in order to prevent the unraveling of a market that Congress is already regulating in a concededly constitutional way. Many markets don't suffer from the adverse selection problem that this statute is trying to address. Thank you.
It is such a pleasure for me to be on this panel, and it reminds me, talking to Stephen Sachs and Neil Siegel before we began, of what I think is really special about Duke Law School. We're in a period where there's been an increasing separation between academic law and law as it is practiced by judges, by people in law firms, by people in government, and that gap is growing enormously. And I say that as someone who is a strong supporter of interdisciplinary studies and who cherishes the great work of theory that we do at Duke Law School, but the two have to be connected up with the world of practice. And I believe that Duke Law School is doing that better than any law school in the country, period. It's not close. And to have someone who is adept at legal theory but has been grounded in the practice and judging of law as dean is very much a part of that. I know, I should say by way of disclosure, that I was in various ways involved in the government's defense of the Affordable Care Act, and you should just sort of know that generally. But one of the things that struck me is on several occasions at meetings at the highest level, people would say there's an article by Professor Siegel at Duke that everybody has to read, particularly on the question, the issue of how you deal with free riders. And I thought, well, I know him, and I'm looking forward. Stephen Sachs has got a piece forthcoming in Law and Contemporary Problems about why this is not an easy case. And I think that brings a really important perspective to the discussion of these issues. Let me add a word to what Neil said about the reasons for this. I spoke to the Federalist Society and decided, given that that's a conservative-oriented legal group, that I would talk about what the conservative case is for the Affordable Care Act and for its constitutionality. And to concretize what Neil said, the 40 million uninsured who don't have access to group health insurance. Group health insurance already has community rating and guaranteed access. When you join the Duke faculty, you get coverage at the standard rates. And so all of us in this room are either probably covered by Medicare, the actual socialized medicine way to approach these problems, or through a group health insurance. When you're outside the group, you don't have guaranteed access, you don't have community rating, or the equivalent of it. And that's the 40 million Americans who are underinsured. What happens to them? 3 things happen to them. One is they go without vitally important health care for themselves and their children. The second thing they do is that they postpone health care until it's chronic. And they, instead of having a mammogram or a pap smear or a colon cancer test, they show up with full-blown metastasized cancer that is enormously expensive. And that's a dysfunctional part of the system. The third thing that happens is that emergency rooms are used as the provider of first resort, which is enormously expensive. So these last 2 ways are enormously inefficient and expensive ways to do it. What happens to it, to those huge uncompensated costs? Because hospitals at the end of the year have to come out even, or after a few years, they're gone. They do it by higher charges on all their other patients. And who pays for that? Basically, through employment insurance. Those rates have to go up to pay for the uncompensated care. That goes into the price of every American product. Every Ford automobile is not just paying for the health care for the UAW. It's also paying for the health care of all the uncompensated care in the hospitals they use by higher charges on the covered people. And the economic inefficiency of that means we have to do something, whether it's this or something else. But that's the hard-nosed economic rationale for doing this. The constitutional case, I will admit, was not thought to be one that was serious, and that's because the individual mandate as such is simply one regulation of an economic part of the economy. The notion that it was outside the scope of the Commerce Clause, when it's part and parcel of this important reform of 1/7 of the economy, didn't strike people as a significant issue, particularly since it is a regulation of how people buy health insurance. Now, if Congress, to me, the most important part of the case is that there is no such thing as the, quote, individual mandate. You can search the 2,700 pages of the Affordable Care Act, and the phrase you will not find is individual mandate. It may be the only phrase in the English language you won't find in the Affordable Care Act, but I have done that full text retrieval. What it is a provision that says that all covered individuals that are within the scope of the Act, which is, must ensure that they and their families have minimum health insurance coverage, or, in Section B, pay an additional amount when they file their federal income tax. The amount is $95 in 2015. It goes up, but it never exceeds 2.5%. And if you're wealthy, it's capped much lower than that because it's basically capped at what the bronze level minimum policy would be. One thing that is really critical, I think, in all the briefing and the argument, is the fact that the government has taken the unequivocal position that the Act provides you with a choice, and that you're acting fully lawfully if you either have the insurance coverage or pay the 2.5% penalty. In the government's reply brief, I think probably the most important, to me, a very important sentence in the case, the government's reply brief says that to the extent that the constitutionality of Section 5000A depends upon whether the subsection creates an independent legal obligation, the court should construe it not to do so. That you have no obligation to have health insurance if you just want to, as an alternative, pay 2.5%. Now, the question would be, so let me address quickly two things. One, are there limits? We're in the Supreme Court. The Supreme Court can state whatever limits it wishes to do so if it were to uphold this financial incentive for people to have insurance coverage. The question would be whether those limits are principled or not whether they can state limits. Of course they can. They're the Supreme Court. The limit they would state is this, that this is an incentive to purchase a product which people will inevitably engage in, or an incentive to purchase financing for a product in which people will inevitably engage, or they have no possibility of avoiding engagement. They will, and when they engage in it, it will be provided for them whether or not they've made financial preparations to pay for it. And the cost will be shifted to others in a way that undermines an overall clearly valid regulatory scheme. I've stated 4 limiting principles in that sentence. And what is so different about it is, would this mean that it's no different than a requirement that everybody buy a flat-screen TV? First of all, what would be the point of that? It would just be a subsidy to the flat-screen TV industry, right? But here's the difference. If I don't buy a flat-screen TV, and it turns out, much to my amazement, that my team makes the Final Four.
God forbid.
I don't get to rush into Best Buy and say, you know, there's a law, that the Emergency Medical Treatment Act, EMTALA, says that hospitals have to provide you with emergency care, whether you can pay for it or not. And that's not just a problem the federal government's making. That is 1,000 years of the medical profession's ethics. And virtually every state law of the state whose attorney general are challenging this law also has a requirement that people be treated when they have emergency care. But there's no EMTALA for flat screen televisions. So when I rush into Best Buy and say, I didn't save any money and my team made the final four, you've got to give me a flat screen TV and just put the charges higher on other people who are shopping at Best Buy this week, right? They laugh me out of the place. That's why there's none of the attributes that you have of this law where we have a system where you're going to be provided with the coverage and the cost is going to be transferred to others. I'll make one final point. I think one of the points that the Chief Justice and Justice Alito made very effectively is that a lot of the justification of the law would justify a catastrophic coverage so that the cost of inevitable, unavoidable is not imposed on others. But this law, the minimum coverage includes things like pap smears and mammograms, et cetera. And those are not inevitable. You don't have to engage in them. If you don't engage in them, other people are not going to be paid for it. How can you justify the rest of this package other than catastrophic care? The Solicitor General Don's really got out the first and important answer, which is once you're within the zone of constitutionality, it's up to Congress to decide the contours of it. But there's a more important point. If you're going to require everybody to have catastrophic coverage so they don't pass these costs on to others, the Neil Siegel freeloading problem, if you mandate policies that only cover catastrophic care, you set up a terribly perverse incentive. That the only thing people get paid for is the chronic illness when they go. So people can't afford the mammogram, but you're on the hook to pay for the mastectomies and the treatment of metastasized breast cancer. So if you're going to cover that, you certainly want to have people to have an incentive to be able to have access to the preventive care. And that makes it sort of necessary and proper. So at the end of the day, I have thought it was going to be upheld. I've always said it would be 7-2. I was 7 minutes into the oral argument. I was backing off of 7-2. Justice Alito's second question took me off of 7-2. But I look forward to it. And I look forward to hearing what Stephen has to say. Thank you.
Well, thanks very much. Thank you, Dean Levy, for inviting me to speak on the panel. Thank you to all of you for coming. Really appreciate all that you do for Duke. I want to speak briefly on the claim that's sometimes made that if the court strikes this down, or maybe even if it upholds it, ultimately it's going to be 5-4, Republican, Democrat. It's really all about politics. That's all that's going on here. The court isn't deciding according to the law. They're deciding according to their politics. I want to suggest that isn't really true and that we shouldn't look at the healthcare case in this light. Now, it's certainly true that the justices on the Supreme Court have different outlooks on the law. You're not going to confuse one of them for the other. And naturally, that makes a big difference as to who a president, who is a political creature, will choose to appoint. So, somebody like Antonin Scalia will sometimes come out on what's thought of as the liberal side, with respect to flag burning. He was the crucial fifth vote in saying that there's a First Amendment right to burn the flag. But that doesn't mean that most Democratic presidents would choose to nominate an Antonin Scalia to the court. And similarly, somebody like Justice Breyer, applying his legal philosophy, would sometimes come out in what might look like the conservative side, saying that we can ban violent video games. But that doesn't mean that somebody like George W. Bush would want to appoint a Stephen Breyer. The justices have their own philosophies about how they approach the law, and those philosophies make them more or less interesting to presidents from different parties. And I want to explain why, particularly with regard to the health care bill, this is an issue where it really is a close case, and where justices' legal philosophies could put them on either side legitimately without looking to politics generally. I mean, this is true also for me. I mean, for all I know, the mandate may be the one part of the 2,700-page healthcare bill I actually like. I don't know because I haven't read the whole thing. I'm not sure many people have, but I want to show that it's really not just a political issue. It's a closer case than many people think, and the court will really have to wrestle with these issues. I'm not going to get into the sort of side issues about sort of, does the court have jurisdiction to decide this case? So that's a very live issue with the Anti-Injunction Act. If it does strike down part of it, should it strike down more of it? The severability question, that's also a very difficult issue. And I'm also not going to talk about yet the tax power issue, whether this could be justified as a tax. Neil Siegel has done some very interesting work on that. Thus far, none of the courts that have upheld the law have upheld it on that basis, and none of the justices seem particularly interested in that rationale, but who knows, that may be what decides the case. But I'd be happy to talk about it further in the Q&A. What I want to talk about are the two main issues that were dwelled on during the oral argument, the commerce power and the necessary and proper clause. And there are three different arguments under the commerce power, and I'll say a little about each. The first is the cost shifting point. The problem is that when people don't buy insurance ahead of time, they just show up in the emergency room or otherwise and use care, other people have to pay for it. Now, cost shifting alone won't be a rationale that gets brings something under the power of the Commerce Clause. And we can see this from a case about a little over 10 years ago called Morrison, where the court struck down part of the Violence Against Women Act, even though Congress found that violence against women imposes significant costs for the healthcare system. People have to get treatment. People avoid using various kinds of services like interstate transportation for fear of violence. And those costs are borne in all sorts of different states. You might be injured due to violence in one state and seek medical care in another. Nonetheless, the court said this isn't, even though it creates economic problems, it's not an economic activity which Congress can regulate under a doctrine whereby individual economic activities that might be local in themselves have in the aggregate a substantial effect on interstate commerce. So because the activity of violence against women isn't itself economic, unless you're a hired hitman or something, that isn't under Congress's commerce power to regulate by creating a civil action. That's what they held in the Morrison case. So in the same way, if it were just an issue of cost shifting, that alone wouldn't justify the requirement that everyone obtain health care. But the argument is, no, this isn't just cost shifting. It's cost shifting that results from an economic decision, a decision not to buy insurance. I think that's still probably too broad of a rationale for the court to buy. And the reason is that it treats the decision not to engage in some economic conduct as itself economic, which is something that can be aggregated. If I don't buy insurance, I'm really self-insuring. That's an economic choice. The trouble is, if that argument works, there are lots of decisions not to buy products which will have impacts on others. So if I walk to work instead of taking the bus, that's the self-provision of transportation. That hurts the bus industry. That's an economic decision. People who make buses are going to be out of a job. They are going to need social services, et cetera. So in that theory, Congress can make you take the bus. And you can spin out lots of examples like this. If I go stargazing instead of renting a movie off of Netflix, that hurts Netflix, and that hurts Hollywood, and scriptwriters in their coffee houses and Starbucks, et cetera. And there's lots of economic, it flows all through the economic system. And the key in cases like Morrison and an earlier case, Lopez, which involved guns being brought near school zones, is that some things are economic in the court's view and some things aren't. That's the line they've chosen to defend. But if you have a rule that every time I don't enter a market, that's an economic decision too, that really erases the sort of economic versus non-economic distinction. Because anytime I try and get out of the market, well, I've really just acted economically, but in a different way. So everything ultimately gets caught in the net. And I don't think that the 5 justices who were in the majority in Lopez and Morrison, and now that some of their replacements on the conservative side of the court, are going to buy an argument that has that consequence. And that brings us to a third argument, which is that, look, healthcare is really different. It's a unique industry because you're inevitably in the market. I think that's what makes this a close case. And I think that it's important for us to pay attention to exactly why is that important. Now, the Solicitor General had an argument during the oral arguments. It said the reason that's important is because everybody's in this market. Everybody buys healthcare at some point. We're just regulating the way you pay for it. You pay for it with insurance. I'm not sure that argument's going to fly, in part because the Act doesn't really regulate the manner of payment. If you buy an insurance policy under the Act, you can still pay for all your health care with a briefcase full of cash if you're lucky enough to have one. There's no requirement that you ever submit a claim under your insurance policy. It's not actually regulating how you pay for coverage. Well, the real issue is the point that Justice Kagan made during the oral argument, which is that everyone's going to use healthcare someday. We could require you, the day you use healthcare, to buy health insurance. Congress could. So the only question is one of timing. Why does Congress have to wait till the point of sale? Why can't they do it right now? I think that argument makes a lot of intuitive sense, but it's still not a slam dunk. Congress can require you to buy insurance when you go to the doctor at the point of sale. But the problem is we don't want to tell people at the point of sale, if they haven't bought insurance, that no, you don't get any health care. We don't want to turn them away at the door. You could also, something that Paul Clement suggested, you don't have to turn people away at the door. You could just say, well, we're going to impose this $700 penalty for all the years you didn't buy insurance, but we'll wait to impose it until you engage in the purchase of health care. You're engaging in this economic activity. That too would be a problem, because people won't have enough money then, and they might not be able to afford the penalty. And in any case, we need to be raising all this revenue beforehand to subsidize the insurance companies to lower people's premiums. So that's not going to work either. And that's the basic claim. Why should we have to wait if it's not really going to work? I think the problem is, as Walter Dellinger stated, finding a limiting principle that is in fact principle. You can imagine a scenario where Congress says, look, everybody needs exercise. If you don't exercise, you are getting the benefit of your laziness, and you're imposing costs on other people because someday you're going to use health care, and that the increased demand for health care drives up the price that everyone has to pay, and so you're really shifting that cost to someone else. And so no one can get health care unless they've been doing 5 jumping jacks a day. Now, obviously, we don't want to impose that at the point of sale, because at the point of sale, you're fat and lazy and have high cholesterol, and you haven't been doing your exercises, and as a result, we don't want to turn you away at that point. So we're going to regulate you today. So as of today, you have to start doing your 5 jumping jacks, because someday you will be in the market and you will be imposing costs that other people are going to have to bear. So the point is that I think the reason why 5 justices might be hesitant about that is that once we put you in the interstate commerce box, there's an awful lot that Congress can do. And if we say that people are in the interstate commerce box before they actually engage in anything, that any economic conduct that in the aggregate affects interstate commerce, that's where you get the fear of something that looks a lot like a plenary power. They can make you do the jumping jacks right now, even though that seems very different from the language of the Constitution that Congress can regulate commerce with foreign nations and among the several states and with Indian tribes. And if Congress can regulate in advance of you actually doing any of those things, it looks less like a commerce power and more like a plenary power. So the final point I want to make quickly is with respect to the necessary and proper clause. I think this is actually the strongest defense of the law. And I think in some ways it was a mistake for the government to put so much emphasis on the commerce power instead. Because the real argument for the law is, if we don't do this, the parts that are concededly constitutional, the guaranteed issue and community rating process, they're just going to collapse for the reasons that Neil Siegel has explained. Why isn't that an open-shut answer? I think the reason is that this is a sort of an unusual use of the necessary and proper clause. Without the mandate, the act can be carried into effect fine. It can be religiously observed. All the insurance companies can make sure to charge everyone the same price until the day that they all go bankrupt because no one's buying insurance. What it's really about is fixing the problems created by other regulations Congress has imposed. Now, Congress can sometimes do that, but they don't have a general power necessarily to fix all of the problems created by other legislation. In a case from a century ago called U.S. versus DeWitt, Congress taxed certain kinds of lighting oil, and then people stopped using that oil and started using other kinds of oil instead. So instead of taxing that other oil too, Congress said, well, we're just going to ban it, so you have to use the oil that we tax so that we can get the revenue. But the court said, no, that's not a means of carrying your tax into effect. You're trying to solve a problem, but it's not the power to ban that other oil, which at the time was not thought of as part of interstate commerce, is not something sort of incidental that goes with the territory of your trying to collect the tax. It's really a whole new power, something that isn't just sort of assumed to go along with the powers you're actually exercising. And I think the worry that 5 justices may well have is that the power to require someone to enter into a contract with someone else, something that looks very suspiciously like transferring property from A to B, is really a bigger and different kind of power than Congress has exercised before. And that even if it might be a good idea, it doesn't mean that that's something that necessarily Congress has been given the power to do. So I'd be happy to go into more detail with that. And I think that in the end, who knows where the court's going to come down, but there are really good reasons why they might decide either way in this question, and it's by no means an open and shut case.
Okay, I can see Walter's sort of approaching the mic.
No. I'll lean back.
Well, let me ask Neil Siegel to reflect a little bit on the taxing power. I saw maybe you winced a little bit when Steve said that none of the cases had relied on the taxing power below.
Sure. I'll first very briefly respond to what he said about the Commerce Clause and the Necessary and Proper Clause. Mandates to exercise would implicate other constitutional limits. Substantive due process rights of bodily integrity. So would forced consumption of broccoli, right? So I think we have to be careful about the hypotheticals we create in order to call the act into question. With respect to necessary and proper, what Steve is saying and what the opponents have said is that it's necessary, but it may not be proper. And here what I want to suggest is that this is a case about limits, but it's also a case about limits on limits. It's not just a problem for the government, it's a problem for the opponents. Because what we have now are new limits being invented, I think, for purposes of litigation. What used to be necessary and proper is now necessary but not proper. Think about the consequences of the argument that Congress can't take steps to solve problems that are partially of Congress's own creation. Think about what that would do to the necessary and proper clause. May Congress criminalize terrorist attacks on military bases? Well, of course, Siegel, you're crazy to think otherwise. Well, didn't Congress create the problem when it created the bases? Who provided the target for the terrorists? You could still have military bases without a prohibition on terrorist attacks up until the point in which the terrorists blow up the bases. May Congress criminalize mail robbery? It has the postal power in Article 1, Section 8. Well, who created the problem? Who put all the mail in one place for Congress, right, for the robbers to rob? So this idea that things are not proper because Congress is trying to solve a problem that's partially of its own creation, I think is itself very problematic. Can Congress deal with a public flu pandemic that's spreading like wildfire around the country? Or do we just have to rely on the states? Or are we all at the mercy of one holdout state that doesn't mandate vaccination on libertarian grounds? Right? Are we really going to talk about activity versus inactivity when it comes to the Commerce Clause? As for the tax power, I think Walter's arguments earlier about an incentive versus a mandate, I don't call it a mandate because it's not a mandate. Right? It's been called a mandate by critics. It's for most people a modest financial incentive. In fact, the problem from a health policy standpoint is that it's way too low to be effective. Right. It's a compromise. Right? So you can see how the Democrats managed to get the worst of all worlds. On the one hand, it's insufficiently coercive to be effective. On the other hand, they take it on the chin for being coercive and coercing people, right? I think it makes no difference for purposes of the Commerce Clause and the Necessary and Proper Clause. If Congress can impose this incentive under the Commerce Clause, it can put you in jail for not having insurance. I think it makes all the difference in the world for purposes of the tax power. What's the difference between a tax and a penalty? There has to be some difference, or else Congress can evade whatever limits the court imposes under the Commerce Clause by just relabeling an exaction, a regulation backed up by an exaction, relabel it a tax and justify it under the tax power. I think the difference between a tax and a penalty is the difference between a choice to get insurance or pay $700 and a quote-unquote choice to get insurance and pay $7,000 or $70,000. And by the way, we're going to increase the amount you have to pay each month you go without insurance. Right? The basic difference between a tax and a penalty, I argue in my own work, is the difference between not raising revenues and regulating behavior. I think Justice Ginsburg and opponents were just wrong about this. It's about how you regulate behavior. Do you dampen the conduct subject to the exaction and thereby raise revenue because you dampen it without preventing it? Or do you just tax the conduct out of existence and thereby raise almost no revenue because of how coercive the exaction is? Here we have the CBO, the Congressional Budget Office, predicting that 4 million people each year are going to choose to pay the exaction instead of getting insurance. It's supposed to raise $54 billion over 7 years. Right? This is much, I think it's clear that the predictions are it's going to regulate by dampening, not regulate by preventing, and so I would argue is within the scope of the tax power.
So can I ask you about this, Walter? I mean, you've seen this, I would think, over the years, how different kinds of constitutional arguments, they just won't stay put, and they tend to bleed over. So, you know, one of our Chief Justices said the power to tax is the power to destroy, and part of what it seems to be going on at least in the public debate is lawyers see this as about the Interstate Commerce Clause, but some very significant part of the American public sees this is civil liberties. This is about liberty. You know, how do you assess that?
Boy, that is a really, really important question. There are two possible ways you could challenge the, quote, mandate, which I call an incentive. One is to say it's outside the scope of Congress's power to regulate commerce. The other is to say it's an infringement on liberty, that people should not be forced by the government who would just like to be left alone to engage in an activity with other people. It's very important to keep in mind that only the first claim was brought. I actually said to Paul Clement, who argued for the challengers, that I sure wish they had brought a substantive due process liberty challenge as well as a Commerce Clause challenge, so the court could see those are two separate questions. Because what has happened in the argument is that the liberty stuff has come in through the back door. And in the very language of the Commerce Clause, they say it's an unprecedented intrusion by Congress. Justice Kennedy said in oral argument, this fundamentally changes the relationship of individual to government. It's never the overt argument, but it's implicit. Because in that sense, if you think of the Commerce Clause argument, it's just a question of whether this is within the subject matter of regulating commerce among the states, good or bad, right? And just as, and so in that sense, the government hesitated to say forthright, first of all, requiring someone to buy insurance in the interstate insurance market is surely a regulation of commerce. That would mean that requiring people to buy anything in interstate commerce was also a regulation of commerce. But at least we're starting out, this is presumptively a regulation of commerce. What should carve it out? And the limits have always been, in that sense, when you're within the subject matter, either other constitutional limits or political limits. When the Social Security Act was argued before the Supreme Court, the argument was made, the opening argument by the challengers was, if Congress could set a retirement age at 65, they could set it at 25 and require everybody, all the young people, to support everybody in the country over the age of 25. And of course it's true, that would be equally a regulation of commerce. When the minimum wage law was attacked as unconstitutional, people said if it's within the commerce power to have a $5 an hour minimum wage, it would be within the commerce power to have a $5,000 an hour minimum wage. Those arguments are always there when the question is this within the subject matter? But what happens here is the liberty argument comes in the back door. And if it were met forthrightly, it would really be very important if the government says you have a choice. You're in compliance with the law by paying the 2.5%. So think of the liberty argument this way. You go to work, you enter interstate commerce. When that happens and you make $18,000 a year, you're subject to federal income tax, they tell you three things in the Human Resources Office. That we're going to take out 7.5% to provide for your sustenance when you're past 65, Social Security tax, FICA tax. We're going to take out another percentage for Medicare. It's going to provide you for health care after you're 65. And you're going to have to pay an additional 2.5% if you don't otherwise have health insurance coverage in order to provide for health insurance before you're 65. Who in the world would say when they got to the third one of those, oh my God, that's the end of liberty as we know it in the Western world? When you're paying 7.5% for insurance and 2.5% if you don't have minimum coverage. So I think part of what goes on is a catastrophic failure of communications on the part of the administration. I believe the President of the United States, first of all, no one knows that also almost certainly at stake are the provisions that allow you to have coverage even though you've had asthma. You can't be turned down now because you've had asthma, you've had a cesarean section, your rates can't be raised because you have a child born with a birth defect. Those are wildly popular provisions. The President of the United States should have gone into the press room the day the attorneys general filed this lawsuit and said 25 state attorneys general have filed a lawsuit, and if it's successful, you can be denied coverage for pre-existing conditions. Your rates can be raised. You have a child born with a birth defect. Make them, take that on. And in fact, they've asked that the whole law go down, and almost nobody knows that that means that if you quit your job at 63, knowing you can now get health insurance coverage, you don't have to keep working until you're 65, you've lost that right. Nobody knows that senior citizens' prescription drug benefits are going to go up if the whole bill goes down. There are vast provisions. So I think the whole severability problem will be chastening to the court because there's no easy or clear way to deal with what else goes down. There's no clean answer, I think, to that at all. So that is my sense that David, that the liberty argument is coming in the back door. It was made in Massachusetts. The prototype for this obviously was Governor Romney's plan in Massachusetts, and it was challenged. There's the same thing, a penalty unless you either have insurance or post a bond. That's another alternative Massachusetts gives you, but otherwise you have to pay a tax penalty if you don't do it. But it was attacked on liberty grounds, and people said, oh, that kind of economic liberty challenge was rejected in 1937 and has never come back. I mean, the courts in Massachusetts made short work of the idea that it violated liberty to tell people they had to pay a financial penalty. And they cited Social Security. There's no more invasion of liberty than Social Security. But I think the conflation of those two arguments has really shaped the debate in a way that if they had brought both challenges, commerce and liberty, the weaknesses of each would have been more apparent to me than when they're put together.
So just before I go back to Steve, so you're one of the great Supreme Court advocates of our time, and you were there at the argument, and these were extraordinary arguments, at least for the 21st century, to have hours and hours and hours dedicated to an argument. And I understand that General Verrilli went to the podium with water having gone down the wrong windpipe, and I'm wondering what what your take was on the manner of the arguments.
Oh Lord, it was it was truly extraordinary. To me, it was an extremely painful 56 minutes. First of all, Paul Clement was spectacular for all 3 days. I've known him for a while. I mean, I think he made arguments that I think are not that sound, are not that solid, sound very persuasive. When Paul says them, they somehow sound very persuasive, and I thought he did an extraordinary job. Don Verrilli was sharply criticized in many circles. The first public comment came from Jeff Toobin on CNN. There was a complete, total train wreck disaster for the government. I don't think that is a defensible position. If you read the transcript, I think Verrilli made all the right points. He made all the right arguments. He articulated the limiting principles. He said this is an incentive to buy a product you can't avoid using, would not justify anything else. I think he went through all of the points. It sounded terrible for two reasons. First of all, Don did have problems. Water went down the wrong way. He had a frog in his throat. Water went down the wrong way. He had to start and stop again. There's 30 seconds that was very, very painful. He was, until he got his footing back. And I was really afraid in the courtroom that he might go down, but he got over that initial moment. He was interrupted in a 56-minute argument. He was interrupted 103 times. 103 times. So that, and at times it seems to me like there was almost heckling going on. And I think the coverage of the court, this is said from the standpoint of a practitioner, I know bad arguments, I've made bad arguments. Don really did not make a bad argument. But the coverage always privileges the viewpoint of the justices. So if you offer up a perfectly sound limiting principle, and the judge says, well, that's ridiculous. The coverage will be that he utterly failed to come up with a convincing limiting principle. Well, no one ever sort of criticizes the perspective of the justices. I think they did not. I don't think any of the. I was really surprised. I think at how relatively poor the performance of the justices was across the board.
Well,
in
we
this
could talk
case.
about that. I mean, I think one question would be, is that a performance? Of it? Oral argument is their opportunity to ask questions. Well, we'll come back to that. So, Steve, you know, Holmes famously said that the life of the law is not logic but experience, and you're making arguments that sound very much as if they are arguments from logic. So you look at Morrison, which was the Violence Against Women's Act, and there'd been a tradition in this country that domestic violence and that sort of thing is handled by the states, not by the federal government. The court very much coming from that point of view. The Judicial Conference had opposed the legislation on that basis. And the regulation of guns, as we know, has taken its own sort of course. So arguing from those cases to health insurance and then making all of the slippery slope arguments, which again are sort of the logical arguments as opposed to practical arguments, I wonder how effective is that, at least from an advocacy point of view?
So I think in this context, you know, in some sense the proof of the pudding will be in the eating. I mean, we'll see how effective it is. I think that it is kind of effective, though, because even though health insurance doesn't have the sense that sort of, oh, this is intensely local and personal. I mean, your insurance company is not your best friend that you hang out with. The justices are still very worried, or at least 5 of them, I think, are still very worried about anything that could seem to open the gates in some important way. And that's why sort of people have talked so much about what's the limiting principle, how does it work? And I think that there is a concern, and there's a reason why these sort of liberty ideas have come into it. And the reason is that federalism, and Justice Kennedy is one of the foremost exponents of this view, federalism and the restraints on the federal government and the reservation of plenary power for the state governments really is about protecting liberty. If Massachusetts decides that it wants to impose a mandate and you don't like it, you can go to New Hampshire, which is, you know, live free or die, and you're going to get a different rule there.
Live free and die.
Yeah, well, you know, it's an inclusive or. You know, and they can make different choices on that. And I think that the justices, I don't think, would be willing to say that the real limits on the commerce power are only the limits of substantive due process and bodily integrity that you won't find in the text of the Constitution. They're going to want limits that you actually do find in the text of the Constitution, like the fact that Congress only gets to regulate commerce with foreign nations and among the several states and with the Indian tribes. So for instance, you take the jumping jacks example. You know, I think Congress probably can make us all do jumping jacks. That's in Article 1, Section 8, Clause 14. They can provide for organizing and disciplining the militia. Sure. If the states want, I mean, the states have to be the officers, but they want us to be in fighting shape. We have to do jumping jacks, that's fine. But that's not part of the commerce power. That's not sort of incidental or something that goes along with the ability to regulate commerce. In the same way, you know, I think that Congress has, you know, sometimes Congress can restrict problems or prevent problems that are of its own creation, in this case the terrorist attacks on military bases, but that doesn't mean they have a general power to prevent all problems that are of their own creation. And the really question is, what tools do you have? What tools does the Constitution give to the federal government? So for instance, Congress could, if it wanted, say that everybody can write letters to their grandparents without having to put a stamp on the envelope, and that's part of the post office power. That doesn't mean they can say, oh my gosh, this is so expensive. In order to cut costs, everybody has to live within 10 miles of their grandparents. That's the sort of power that wouldn't sort of go along with the territory, even though it might actually be necessary to make the law that Congress did have the power to do not be a terrible idea. And there are limits on the sorts of tools that Congress has in its toolbox to fix the problems of its own creation. Finally, I just want to speak very briefly to the tax power issue. I do think that often the label that Congress chooses matters. If Congress wants to prohibit treason, it has to give you, it has to have 2 witnesses in open court to an overt act. That's what Article 3 says. If they want to have the same punishment for espionage, they don't need that requirement. The label actually matters because whether you're a traitor or whether you're a spy is a different category under the law. And, we have a different category under the law for whether you get a choice of, perform or pay, or whether you're just under a legal duty to get insurance. And the court, may very well read this text as imposing that legal duty. And what the government was saying was, if it makes a constitutional difference, read it as if it gave you a choice, not that that's the most natural way that you would read it anyway. And I think whether the court ends up buying the tax power argument will depend a lot on whether they think it is susceptible of that as if reading.
Okay, so I'm going to take the moderator's prerogative and give Neil Siegel all the remaining time, which is till 12:30. He has been writing so extensively and marvelously in this area, and we're very proud of the scholarship that comes from Duke. And as Walter said, it truly is knowledge in the service of society. It's highly relevant. You can agree with it or disagree with it, but you will be enlightened by it. So, Neil, you have the time.
Well, in the beginning, picture ancient Greece.
In Principia or Adverb.
I do think this is a place that takes seriously the idea of knowledge in the service of society. We have really a first-rate constitutional law faculty. We have a first-rate federalism faculty, and we have a genuine intellectual diversity of views. If Ernie Young were here, I think he'd be arguing vigorously in much the way, I think more vigorously in the way that Stephen Sachs is. And so I think we take great pride in that, and I personally take great pride in the idea of producing scholarship that's both theoretically rigorous and also has something to do with what's going on in the world. I think it informed my choice to come here, and it's not a place in which doing that is merely tolerated, it's also promoted and celebrated, and you can see that from what the dean has had to say. And so I think it does distinguish this place. We're not trying to be as close to Yale Law School, for example, as we can, right? We're trying to be our own place, and it's a place in which we take theory and practice very seriously, apart as well as in their integration. As for this litigation in particular, there's certainly a sense in which it's easy for me, it's easy for Walter to think that this is a very difficult political case, but it's not a very difficult constitutional case, and people can agree or disagree with that, right? Stephen obviously disagrees. I think when this is over, and whatever the U.S. Supreme Court does, I hope that certain Court of Appeals judges will be remembered, because to me, I think they're frankly, I think they're the heroes of this story, right? It's easy for me. I don't regard myself as a crazy liberal, but I certainly am left of center. I support this administration and this law, warts and all, and there's plenty I don't like about each. But I don't think the same could be said of Larry Silberman on the D.C. Circuit, or could be said of Jeff Sutton on the Sixth Circuit. I mean, these are leading lights of the Federalist Society. These are some of the most respected conservative jurists in the country. Brett Kavanaugh on the D.C. Circuit, who thought there was a jurisdictional problem and raised problems for both sides on each side of the merits. I think about Charles Freed at Harvard Law School. I think about Orrin Kerr at George Washington Law School. These are very, Doug Laycock, right, who's no liberal. These are very prominent legal conservatives, whether in the judiciary, in the academy, who think whatever they don't like about the law, in fact, they don't think it's a particularly close case as a constitutional matter. They think it's clearly within the scope of Congress's power. Now, you may disagree with them. You might think it's unconstitutional. You might think it's much closer than they do. But I think if you want to think of the idea that law and politics, constitutional law and constitutional politics, are not coextensive. They're not just the same thing, even though in my own work I've emphasized the ways in which the boundary is ragged and blurred. I think you can see what was going on in the Court of Appeals with those kinds of judges, those kinds of academics coming out on this question the way they did. I think it was much more difficult for them to come out that way than it would be for someone like me, and I think we ought not to forget them once the Supreme Court hands down its decision. So thank you all very much for being here today. That was great.
Produced by Duke University. Online at duke.edu.